Good afternoon, everybody. I hope everybody's doing well. Thank you for joining us on the session of Legal Practitioner Mentoring. We're hoping to be of great assistance to you. We're going to be talking about consultations vis-a-vis counsel, as well as client, as well as consulting with experts. As in the course of litigation, you would have to consult with experts from time to time. And to guide us and take us through that, Ian Barkhuizen will be guiding us. Thank you, Ian, for joining us.
Thanks, Bruce. I appreciate the introduction. Apologies for being late. I had an emergency consultation that ran a little bit over. Be that as it may, it fits quite well into our topic for today. So the topic for today is threefold, all of which are intertwined. Consultation with clients, consultation with experts, as well as consultation with counsel. You cannot go to trial without having done these three, particularly, for example, in a personal injury dispute. For example, you're suing the MEC, the Minister of Police, or whomever it may be. The blatant fact is you must at some stage consult with client, you must at some stage consult with your experts, and you must at some stage consult with counsel. Now, I'd like to bring a caveat to everyone's attention. When I refer to counsel, it is an umbrella term for any person who has rights of appearance, as there is a plethora of case law which denotes a person appearing and who has the right of appearance and a power and authority to represent a client to be considered counsel. This is apparent from the case law, as well as if you have a look at the Johannesburg Practice Directive, for example, or the Practice Manual, apologies. It denotes attorneys and advocates to be under the umbrella term as counsel. Therefore, attorneys and advocates can charge and be taxed as counsel and representing clients in court. Okay, moving on. Consultation with counsel with clients. This is your first. Consider your person comes in today. They most likely made an appointment, or they've come to you with a reference. So you have a good idea on what your client basis would be. For example, if you have a reputation as being a commercial firm of attorneys, the chances are this person read on the website that this is a firm of commercial attorneys specializing in, for example, contracting or evictions of commercial properties. Now, having a background or a basic understanding of the laws surrounding your area of speciality is foundational when it comes to consulting with client and being able to afford that client good, sound advice. It need not be the best advice initially, but it must be good, it must be sound, it must be based on reason and law. Make no mistake, if you advise a client poorly, you will most likely be sued for malpractice or negligence. It is a factual common occurrence that attorneys and advocates are sued for negligence, irrespective. It can result from not knowing the law properly or failing to apply the principles properly. You are then deemed negligent. That is a presentation for its own in due course. Now, during a consultation with a client specifically, you'll then have to categorize these clients. You can have a learned client or an illiterate type of client. Now, learned I would classify as anyone who is within the realm of a corporate employment or has a formal qualification beyond matric. I say this with no derogation to a matriculant at all. Please don't misunderstand that representation. In respect of a uneducated or up to matric, they will have a basic understanding of what has happened and what they need to discuss. An educated person will most likely have a background knowledge of the subject matter, as well as most probably have experience in this field. For example, if you are consulting with a doctor who had a broken leg and then subsequently suffered sepsis in hospital due to negligent nursing care, This doctor will most likely know and understand the laws and rules as well as guidelines surrounding the standard of care which had to have been offered. Whereas on the contrary to an educated person, an uneducated person will come to you and will say to you, I broke my leg. I went to hospital to get it fixed. They ended up having to cut my leg off. I don't understand. Being able to differentiate between your types of client will most likely influence the manner in which you give advice during that consultation. It's more often than not that you will only discover the level of education or the level of intellect which a client possesses during your initial consultation. You'll be able to gauge, engage, and react at a much greater speed with the more often you consult with clients. Importantly, during your first and subsequent consultations with client, you must take a proper set of facts and you must ask your client directly, what do you want me to do? After that, or even actually before that, you need to ensure that your power of attorney has been signed should you be acting in any representative capacity. If a client comes in and merely asks for advice, I would still highly recommend having a power of attorney signed, and this client may only want a brief opinion or a letter or a basic 2,000 rands worth of work done just to see where they stand, for example, before they enter divorce proceedings. This is all something which you have to gauge from your client within the first 3 minutes of your consultation. It does not happen overnight, and you are not going to master this skill within the first year of practice, let alone articles. There are many people who are able to, and I genuinely respect them. Now, in the scenario where your client has called in advance, or a potential client is called in advance, and you are able to, or your secretary is able to obtain a brief outline of what type of advice they seek, for example, a contract for a sale of business, you will then be able to most likely go through your own history of work and find if you have done a type of sale of business agreement prior to that. You'll perhaps be able to get a lot of information from what you need from your client at that initial consultation. This is beneficial for a number of factors. You are then able to more readily engage with this client, and you'll be in a much better position to extract exact instructions from this client. Going through your consultation, you will then obtain your instructions, your mandate, as well as your prospective outlooks. Very importantly, you must discuss the aspect of costs of advice with this client and your costs going forward. The LPC has of late taken umbrage to fees which are levied at a later stage, and many clients go to the LPC and complain that they were never warned. It's for this reason that I have my clients sign a fee agreement when they sign a power of attorney. This sets out what is exactly my fees going forward and what is exactly expected from my clients. I'd highly recommend a similar system in your practice, whether you are a candidate attorney or a legal practitioner currently practicing, or even an advocate. Your clients need to understand that your services are not free and not subject to any discount because they think they're your friends. You will discover this is a major misconception. Clients spend so much time discussing things with you that they believe that they've struck up a friendship and are entitled to a discount. Moving on from clients, you then get to the point of most likely engaging with counsel or with experts. Yes, Bruce. So
sorry about that, guys. A little bit of lag. Something that's also rather important during the consultation with your client is to manage the expectations and also ensure that the desired outcomes are 1, practical, 2, reasonable, and 3, within the realm of possibility. Having done a little bit of RAF work in the past, some clients came into the office and they were expecting millions for somebody driving over their foot, as a bad example. It might be possible, but very, very unlikely. And it is your duty to advise clients of the realities of the facts, also the pitfalls in their matter. I highly recommend this because more often than not, some clients they think everything is guaranteed. As legal practitioners, we can't guarantee any sort of outcome, and hence it's incumbent upon you to indicate the shortcomings in the matters and rather do this rather expressly, as clients tend to have this belief that attorneys can do magic. Sorry about that, Ian.
Not a
Thank you.
problem. That was very welcome input, and I'm grateful for the input. And it is exceptional advice, in my opinion. I'd highly recommend implementing that advice without a delay. Okay, then moving on to counsel and to experts. Usually these go hand in hand, and it depends the type of matter and how experienced you are in your practice, the order in which these consultations will take place. Generally, if one speaks of, for example, medical malpractice, one will then engage your counsel prior to, and it is more likely than not that it will be a counsel with a number of years of experience in that type of matter. You will then set up a consultation with your counsel. You'll brief your counsel well in advance, preferably more than a week. And you will set out the various goals for your consultation which you seek to achieve. Just as an interesting side note, consultations with counsel where the plaintiff is not present or your client is not present does not fall within the realm of party and party costs and will be taxed off, or most likely taxed off if not agreed upon. Moving on, at consultation with counsel, assuming that your counsel has read the brief, albeit even for an hour, this counsel will then understand the form of matter, the type of matter, as well as what is expected from clients, as well as themselves. It will put them in a position to be able to render advice in respect of possible experts, or in respect of experts' reports or opinions which have already been obtained. To give this a bit of context, if a medical malpractice matter pertaining to a cerebral palsy child goes to a counsel, you'll most likely start off with your liability aspects with a number of experts to prove that cerebral palsy was linked to negligence at birth. On a different spectrum, you may approach a counsel with a problem for latent or patent defects with a report of an assessor already in hand, outlining the exact types of damages which could be considered latent and or patent. It is all contextually based, and it is best left in your opinion how to approach that consultation. Bearing in mind, it is incumbent on you as a practitioner, whether candidate or legal, admitted or non-practicing, to understand the contents of the brief which you have provided to your counsel. You should know that brief better than any counsel, any briefed at any given stage. You are the administrative driver of that brief. Whether you are plaintiff or defendant, it makes no difference. You need to understand your brief with such intricacy that you do your client justice. It's not to say that you can spend 7 days reading your brief for a 1-hour consultation based on your experience, which would then result in a 20-minute consultation. That maths does not work, and your client will most likely report you for overreaching. It is also your duty to control the consultation with counsel and to guide counsel in respect of the aspects for which advice has been requested. It must be remembered, a counsel is a specialist litigator. They are paid day in and day out to go through the rules of court and the case law surrounding this specific aspect, for example, latent and patent defects. A counsel who is well versed in that field of law will most likely have a plethora of case law ready and to hand, as well as be up to date with the most recent case law in that field and pertaining to some specific types of damages or patent defects or latent defects. It is that aspect for which you pay counsel. Please do not be disillusioned to counsel charging 2,000 Rand an hour versus a junior who charges 800 Rand an hour, and conflate that their advice would be the same or their opinions would be of equal worth, and therefore the 2,000 Rand an hour counsel should drop their price to an 800 Rand an hour fee. You are paying for that person's experience, and your client is entrusting you, specifically entrusting you, to make a decision on which counsel ought to be appointed based on their experience versus their costs versus years of experience in that specific field scenario. If you are unable to control your counsel, and I say this with a lot of respect, your counsel will most probably run up fees for the mundane aspects. 5-minute call here to confirm this fact, 5-minute call here to confirm that aspect, 2 hours of research to consider an aspect which, in your opinion, should have been omitted as you have already researched that point. So you understand that it becomes a double research point, and you must ensure that your client's interests are kept at the forefront of your consideration. Your fees, regrettably, are considered to come second by the LPC. As much as we do not like to hear that, your fees come second. If your firm is a firm that operates under the Contingency Fee Act with many of its agreements, you will then note there is a very recent case from Mpumalanga, Mbete versus the Road Accident Fund, which sets out the requirements for an affidavit which must be placed before the court in respect of any settlement. It's mind-bogglingly complicated, but it comes down to the client must be in a better position than the legal practitioner. Ergo, the client's interests outweigh your fees. This will most likely be the theme of many cases to come, irrespective of whether it is a contingency fee agreement or not. The client's interests are most likely weighed of utmost importance. Now, having traversed these consultations, and I've used the very basics of your initial consultations as the starting points, one will then move to, for example, an expert opinion or a consultation with your expert. Now, I'm going to use a medical negligence perspective again. When considering a medical negligence matter, your expert will have already given an opinion, and your consultation will be based on that opinion. Now, please do not be disillusioned that your counsel will know your case better than what you will. It is unlikely. You know your records better than what your advocate will know the records. You know your report and your records better than anyone else. You should be in a better position to engage with that expert than what your counsel would be. And I say this very tentatively. It is more in the interest of your client to be able to control that consultation with that expert with a view to obtain the advice and or clarity based on that report. Going back to the latent and patent defects aspect, if you have any experience in the field, you will be able to identify, for example, mold, which ought to have been picked up, or damp damage that ought to have been recognized as a pre-existing aspect on the date of sale of a house. You cannot leave all of these things for counsel to ask the questions. You need to ask these questions of yourself beforehand. Make a note on your own opinion, and then be able to raise these opinions and these thoughts with your expert confidently, clearly, and succinctly. Again, please do not think that just because you've paid this expert X amount of rands for their opinion, that you're entitled to 7 hours of their time to go through every line of that report. You will find yourself at the end of a very short list of people which that expert will refuse to work with in future. They may tolerate you for one matter, perhaps two, but after that you will find yourself at the short end of a very short line. And that is my general presentation for consultations with client, experts, and counsel. I'd like to open the floor to all of our participants to ask as many questions as they like or to propose any scenarios in the chat. I'm more than happy to assist in the remaining part of the presentation. Bruce, if you have anything to add, I'd more than welcome it.
Actually, there was something I wanted to mention about counsel. And this is more because sometimes in the realm of litigation, I am a little bit more aggressive than counsel. So it's rather important that you, when you're instructing counsel, you are very clear with what you require from them. For instance, should you require certain relief in a certain formulated in a very specific manner, specifically instruct counsel they are not to tamper with the way it's been formulated. And this actually comes to the fore more often than not where you're asking for cost orders, especially cost to bonus purpose. I can't tell you how many times I've been actually instructed counsel to seek cost to bonus purpose and it did not happen. So again, record it, make it sure it's express so that there's no uncertainty as to the instructions. It's clear, counsel knows the limits of their instructions. Also, I've also noticed something with other advocates in that the moment they receive a piece of work, they assume that you're asking them to do X, Y, and Z. Do not be bullied by advocates into paying for work they did that they were not instructed to do. Remember, they are agents. They can only do as they are instructed. Although this might result in the destruction of a particular relationship, but bear in mind, those sort of advocates, unless they're adding real value, and unless there is what they were doing had a great outcome, those advocates typically do take chances. So bear that in mind. And I'm not saying all advocates conduct themselves like this. Thankfully, they are in the minority. And I hope it remains that way, truth be told. Thank you.
I would just like to add to something, Bruce. This again goes to the management of your counsel and ensuring that their instructions are clear and concise. The moment you give them an open book to manage the matter, you will find yourself with a 300,000-400,000 rand account, and more than likely your client will not want to pay that amount of money for a simple aspect of a trial, for example. This puts you in the position where you will then most likely have to settle the invoice with counsel and attempt to recover the disbursement from client, which will most likely end up in you having to sue your own client for outstanding fees and disbursements. Again, comes down to managing your counsel, comes down to managing expectations, and it comes down to your skills as a management of a litigation process. Again, and I can't say this enough, the LPC views the interests of clients above the interest of the practitioner. And to be very honest, we would be fools to fight against that. Yes, we are entitled to be paid for our work. Yes, we can charge on a sliding scale based on our experience and our years of practice. Yes, if you are a specialist in a certain field, you may be able to levy a certain type of fee at a higher rate because you're more proficient in said aspects of work and will be able to dispense with that type of work in a much faster and more ethical manner than, for example, a newly admitted practitioner or a legal practitioner. But it comes down to don't overreach. Again, Manage the file accordingly. Manage it ethically and do not take chances on leaving an open checkbook. You will get taken to the cleaners. Bruce, anything else from your illustrious 7 years of practice?
Must be honest, it feels a little bit longer than that. But that aside, I couldn't agree more with you that that facilitating the relationship with counsel, client, as well as experts is paramount. And also finding counsel experts that you have a good synergy with is great. For instance, something that we do is typically what I like to do is, okay, counsel, we've got this unopposed application. It's literally ex parte. It's literally you appear and say, please grant it, and 99% of the time it'll be granted. And we say, okay, let's fix the fee there. But when you get the post matters, well, that's up to you, counsel. You tell us what is at the bottom line and how much we need to get from client. So using these sort of things and tactics, you can actually grow the relationship with you and counsel, as this way counsel's willing to give a little on the matters where it is justified, and it's made up on other matters where obviously there is that room to negotiate and talk. But again, communication is key, and keep it in writing. If you don't keep it in writing, I promise you it's going to come back to bite you in the butt, guaranteed. That's one guarantee a lawyer can actually give you.
That's in an open checkbook will bite you as well.
Very true.
Are there any other questions from the floor?
Strange how everybody gets quiet at this time.
One would think that the amount of talking we do, they'd want to tell us to stop talking.
Fair enough. Fair enough.
Is there any insight that anyone can offer which would be of assistance, or a problem sharing which we can assist, or a case study with which you can assist? Yeah, it appears that's it.
Well, thank you all for joining. Thank you, Ian, so much. Always very insightful. Again, dealing with counsel, dealing with clients, dealing with experts. Quite a bit of it tends to come by experience, because there's really no right or wrong way to do it, but there are certain golden rules, as you pointed out. And again, this is to help you increase the efficacy of your practice as well as your trade as you hone it over the years. But thank you all so much for joining us. Thank you, and go well. And we look forward to seeing you in the next one. Thank you, Ian.
Yes, on the same link 2 weeks from now. Cheers, everyone.
Bye all.
Yes, thank you. Bye.